What do I need to put in my Texas non-compete? I'm Zach Wolf. I'm a Texas trial lawyer. And that question doesn't come up for me as often as I'd like. Most of my practice is litigation, which means that in most cases when a client comes to me with a non-compete issue, the non-compete was already drafted and signed long ago, and there's nothing I can do about it at that point. But sometimes I talk to clients who have businesses and want to have their employees sign non-competes, and they want to know what should go in the non-compete agreement. Before you get to that question, though, I suggest you go to my blog, 5 Minute Law, and check out an article I wrote about the best kind of non-compete agreement. What I said there was that the best non-compete agreement is a happy employee. And the point I was making is that before you have an employee sign a non-compete, think hard about whether that's really the best thing for your business. Okay, so let's say you've done that and you've decided, yes, I want to have my employees sign non-competes. How can I make sure that the non-compete will be enforceable under Texas law? Well, there are no guarantees, but I'm going to tell you 5 things that should go in your Texas non-compete to maximize the chance that it's going to be enforced if you have to go to court. Marker, please. Thank you. The first thing is that you want your non-compete to have an express promise to provide confidential information to the employee. Sometimes an agreement will have an implied obligation to provide confidential information to the employee. And Texas courts have said that an implied agreement to provide confidential information can support an enforceable non-compete. But if you're writing the non-compete on a blank slate, you might as well put an express promise in the agreement that yes, the employer will provide confidential information to the employee. Then you don't have to worry about arguing over whether there was an implied agreement. The second thing that you want to do in your non-competes to make sure that you maximize the chance of enforceability is to actually provide confidential information to your employees who signed the non-compete. Ideally, you'll have some document in the employee's file. It could just be an email, something that simple, showing that shortly after the employee began work, you actually provided some type of confidential information to the employee. Let's say maybe a customer list. That would be a good example. So you want to actually provide confidential information. The third thing you want to put in your non-compete is a reasonable time limitation. There's no magic number for what a Texas court will say is a reasonable time period for a non-compete, but a good rule of thumb is 1 year. The issue here is what is a reasonable amount of time to protect your business's goodwill. If you put 1 year, you're going to be in good shape most of the time because you'll be able to make a strong argument that 1 year is a reasonable period of time. Now, employers usually want to make it longer than that, and I can understand why. But the longer you go over 1 year, the more difficult an argument you're going to have to make that the period was reasonable. The fourth thing that you want to have in your non-compete is you want a reasonable geographic area that the non-compete applies to. The best way to do that in the typical situation of a sales employee is that you want the geographic area to be roughly the same as the sales territory that the employee covered. If you do that, you're going to have your best chance of having the non-compete enforced. There is an open issue in Texas law about whether an express geographic limitation is always required in a non-compete. But why even get into that issue, which is unsettled at this point? The best thing is put a reasonable geographic limitation in the non-compete. Finally, the fifth thing you want to have in your Texas non-compete, if you're an employer, is you want it to be reasonably limited in scope. A lot of times you'll see non-competes that are extremely broad in scope, where they say that the employee cannot work for any company that is competing in the same industry as the employer. Some Texas courts have called that an industry-wide exclusion, and they have said that that is too broad. So don't put an industry-wide exclusion in your non-compete. The better thing to do is to tie the scope of the non-compete to your customers. That's what you really care about the most. You want to make sure that that employee doesn't leave and then take off with your customers. So limit the non-compete in its scope to your customers, and you're going to maximize the chance that it will be enforced. If you'd like to read more about non-competes, I recommend my blog, 5 Minute Law. You can find a lot of good information about all the things I've talked about today. Thank you.